And welcome everyone to the 36th edition of the Deserve to Win podcast. As always, I'm your host, Eric J. Troutman, the czar of the TCPA, the czar of just about everything these days. Amazing show we've got for you. Let's start with the guest, Jacob Ginsburg of Kimmel and Silverman. Really cool guy, files a ton of TCPA cases, really like a hard-working fella, pretty interesting guy. I think you're gonna like him. He's not like super famous like the Wolf, but he's definitely somebody that is making waves in TCPA world, and you're going to want to hear about him. And there's so much else to cover. I cannot wait to talk about Cal. But before we get to the Golden Bears, let's find out who we have first. The lovely lady to my left.
Hi guys, my name is Brittany. I am a partner at Troutman & Mean, also known as the Baroness of TCPA World.
Wonderful, Baroness. It's good to have you back. We missed you last week. And over to my far right, looking redder than ever before.
My name is Tori Guidry. I'm an attorney at Troutman & Mean and the dame of TCPA World.
And my dame must always be redheaded. It took me so many times. How many times did I nag her live on the Deserve to Win podcast to get back from blonde to red? And it worked, and I'm so happy. And on my right, of course, my colleague and world traveling friend.
Hi folks, world traveling friend. Pooja Amin, Queenie of TCPA World. Happy to be here.
We travel the world quite a bit.
The country.
And the world.
Sometimes.
We went to Vienna.
We did.
That's the world. That's the whole world. So there's so much to talk about. All right, so speaking of the world, we changed it today. Now, you're not going to see this the same day, but we launched troutmanandmean.com, the brand new website. We had the old troutmanandmean.com, which was cool. It was stylized. It was fun. It was in your face. There was a lot of interesting stuff to the old website, and I did like it. I mean, hey, it was me. I designed it. But our new website, I love it. I just think it's so much more on brand for us right now. It really shows just like how dynamic, cutting edge, and really kind of at the forefront of everything we are. Obviously TCPA, but data privacy, AI. And hey, it's actually got words on it, so you can find out what we do, what kind of practice areas we have. You actually know that we're lawyers as opposed to maybe celebrities. I don't know. What do you guys think? I mean, website, awesome? Thoughts?
Awesome. Yeah, I think it's amazing.
Yeah.
It's very sleek.
Without question, and the three of you, of course, look incredible, right? Like the big cherry on top of this website is the video segments, right? Because there's no pictures for the team. If you go to the team, you'll see the ladies and really all of us walking in, right? And so it's all video. And of course, when a video element is involved, right? Anytime there's like a picture, there's always like a weird kind of face. It's never quite right. But with the video, you can really, I think, see what the person's about, right? You can really get that engagement. And you ladies look incredible, of course, but really the whole team does, because we've got nothing but an incredible team of incredible attorneys who are killers, absolute killers. And when you go to that website and you see these people, there's like no doubt, like you look at this person and you're like, man, if I have a lawyer, this is the kind of lawyer I would want. Like this person is sharp, intelligent, incredible background. You just like see, right, like kind of into your soul, like who these people are. And I love putting us on display that way. It's like this beautiful jewelry case and like where the gems like gleaming. Because I mean, honestly, we are not afraid, right? Most attorneys at most law firms, they kind of suck as people. And maybe they're decent lawyers, maybe, but they don't want you to like actually look at them, right? Here's one little picture. Sometimes they're smiling, sometimes it's black and white, very limited engagement. The best you're ever gonna see is a website where it's like the full page and like they're standing up. You can get like maybe a better sense of them, but nothing pops like video. Like you're not gonna get to know a person in an image, no matter what that image is. Yeah, sure, you might be able to project a brand, maybe, but if you really wanna let people get to know you, video is the way to go. And that's what we wanted to do. We really wanted to invite everybody to check us out, right? I mean, you buy a car, you test drive it. You buy a lawyer, you can't really test drive the lawyer, but at least you can have the opportunity to like see what this person's really about in a video segment. And so that's what we did. So hopefully you enjoy that. I love it. I think it's fantastic. Also fantastic, by the time you see this, finally at long last, our logo will have actually appeared on the 25-yard line at Cal Memorial Stadium for a live, real-life football game. The first one will be against Texas Southern. So Cal already won a game. All right, we went up to Corvallis. We beat the Oregon State Beavers. We beat them pretty bad. Our team looked pretty good. We got this really slick 5-star quarterback. He's a freshman, and I can't even pronounce his name, so I'm not going to try. But he is beautiful. He's a beautiful little man, and he is so talented, and we are crushing it. And we're not going to lose. We're not going to lose a single game. That's my prediction. This is my prediction. We're going to run the table, and we're going to win every single game. But in seriousness, we've got a very favorable schedule. ladies. Like, this is the best year, I think, possible for Cal football, because we're in the ACC, which is very top heavy, right? And we don't play Miami, we don't play Florida State. We do have a very tough game against SMU, but that's the very last home game for us. So we get them at home, and it's at the very tail end. And so this team could have a bunch of wins between now and then, because honestly, and look, I don't mean to disrespect anybody else out there, but we've got nothing but winnable games. We've got a tough game against Duke at home, but other than that, it's just nothing but winnable games, right? So we could literally be 8-0, 9-0, 10-0 going in to face SMU. I'm telling you, this could happen. I'm not saying that it will happen, but it could happen. And I love the fact that it is the Troutman Amin deserve to win brand, right? Our je ne sais quoi operating to help the Golden Bears, the Golden Lion, helping the Golden Bears to hopefully become a championship caliber team. And if you think about it, if you just stop and think about it, we're talking about the California Golden Bears. This is the team that represents the largest and greatest state in our nation, representing the greatest public university in the world, right? A beautiful coliseum with, honestly, probably the best views in all of college football. This is a gem of a location. The fact that this team has not won championships very often, and certainly not for a long time, this is a sleeping giant. Like, people don't understand, this program is a sleeping giant, and I am so happy that hopefully Troutman Amin will be the spark. We'll be the ones that got in there, recognized it, and said, look, there's no excuse, guys. It is time to start generating championship caliber teams right now. And Coach Wilcox is a great coach. I think we got a chance. Look, I know that I'm supposed to be breaking down TCPA, and instead I'm breaking down Cal football. But look, I mean, I'm gonna start blogging about Cal football every week, because this is a very important thing, and I love that Troutman Amin is literally all over it, like all over the field. But let's talk about what we're supposed to be talking about, which is TCPA. Sapin versus Safeway. Oh, wow, what an interesting case. Listen, good win for Safeway, sort of. Terrible loss for Safeway also. So let's talk about the good news first, the win. I don't know why, but the plaintiff's lawyers sued them on a TCPA class action over messages regarding the availability of a COVID vaccine. These are from like back in 2020, 2021. You guys remember 2021? Like, the world was melting down. 2020, like the world was melting down. Remember? I don't remember who the president was, but like the world was melting down, and it was terrible. And so we had a vaccine, and it was supposed to help people. Maybe it did, maybe it didn't, but it was supposed to. And so at that time, CVS is sending out messages telling you, hey, if you've got, you don't want to get this terrible disease, come get this now available vaccine, right? Pretty clearly an emergency purpose message, right? This is emergency purpose, can be narrowly tailored. Sometimes it's broadly interpreted. But when you're talking about health and safety, certainly an emergency, a national emergency like COVID, and a notification about the availability of a vaccine that, again, ostensibly is supposed to help, this is pretty clear cut within the emergency purposes exception. And no surprise, the court found that it was sent with an emergency purpose. So you cannot sue for that message. So the case was dismissed. So what's the loss? Well, the court really should have never even been considering that issue, because Safeway moved to compel arbitration. And this is actually the bigger holding of the case, and something that really everybody in TCPA world that looks to enforce arbitration provisions, and particularly you retailers out there that use POS, those point of sale systems, in order to get opt-ins, wow, listen up. Because here's what happened. The POS display was there. It said basically put in your information to receive text messages. I think there was some kind of additional call to action, like you might save a couple of bucks or something. The consumer puts in the phone number, clicks a button, right, to subscribe, but guess what? There's no terms of service there. The terms of service is sent via the first SMS message to the phone. The terms of service comes in, there's a link, you click the link, and now there's going to be an arbitration provision. But there was no mention of the arbitration provision apparently on the POS system, and if the consumer clicked the link, what they would find out is that merely by continuing in the text message program, they have been deemed to accept the arbitration provision. Now, there was a case that came out just like 3 weeks ago in a different jurisdiction where the court said, yes, continuing to use a service after constructive knowledge of the arbitration provision is sufficient to constitute a binding agreement. This case came out the opposite. Sapin said no. The court in Sapin said no. Just because the consumer continued to use the service after having constructive notice through that link, that is not the required manifestation of affirmative assent that the Ninth Circuit Court of Appeals is going to require. So if you're here in California, this is a big deal, right? If you are a retailer that is using a POS system with a two-step dance where you sign in, you get that message, and it's embedded in that hyperlink, you might have thought, hey, this is okay. Well, guess what? This district court says it's not. And that has got to hurt, man. If you are Safeway, think about how many people have accepted terms in this way. And look, I don't know, I did not go through the whole POS system, but to the extent that they're relying on the same process, not just for arbitration, but for consent, ooh, doggy. They are in some trouble. That is gonna hurt almost as bad as me saying, ooh, doggy. I don't know where that came from. So what the hell was that? That was weird. Anyway, we're having fun. So Safeway, not having fun. I actually really feel a little bit bad for them because that's a tough loss. That's a tough loss. They had another issue though, and honestly, this is probably a situation where, you know, they ended up making bad case law because of an unfortunate evidentiary miss. They actually submitted a declaration from one of their custodians, but the custodian failed to testify that the records that were generated at or near the time, contemporaneously to the event reflected in the record, which is a pretty basic requirement of a business record declaration. And so because that declaration was not accepted into evidence, and because the court essentially was going to rule against Safeway, I think on the basis of a lack of evidence, it created the alternate path, and it basically said, even if I found that the plaintiff had filled out the POS, in other words, even if I credited the evidence on appeal, right, you want to give that alternate basis for the ruling to make sure that you're going to get sustained on appeal. The court said, even if I had basically considered the evidence, even if the plaintiff had opted in on the POS system, even if the text message had been sent with the link, with the arbitration reference, even if all of that happened, which again, the court did not credit that evidence, but even if all of that happened, the court still found it would not have been enforceable because of the lack of an affirmative action demonstrating assent. This is a big deal. What do you think, Pooja? Is this something where we've got to get a compliance alert out? What are you thinking? You just well, that's it.
I mean, you blogged about it this morning. We've already gotten recommendations to certain clients who are evaluating their arbitration agreements and their disclosures. Yeah, our compliance team's all over it.
This is how fast Troutman and Mean moves, right? Other law firms, they haven't even heard of this. They haven't even heard of this, right? We've already identified it, we've blogged it, we're talking about it on a podcast, and we've already got alerts going out to our clients to make sure that they know, hey, look, you got to update. You got to make not just changes to your terms, right, but changes to your process. That is a very interesting and important nuance for people to keep in mind. But we love you clients. Those of you who aren't clients, call your lawyers. Be like, hey, guys, why didn't you tell me about this? This might matter. Especially if you're in the retail game. My goodness, this is important stuff. Okay, so what do you think, Baroness? What do you got?
Yeah, so sort of in line with, you were talking about emergency exceptions. I have a case, Clemens versus Consumer Business Solutions. But before we dive into the facts, every now and again we see a case where a plaintiff fakes interest in a call and invites further calls on the line and then ends up suing for those calls, which is frankly ridiculous to us.
Crazy.
But if you're suing for violations of the TCPA under the D&C provisions, it requires calls made to a consumer with the consumer's written, prior express invitation or permission if the call is made for a marketing purpose. Now, there is an exception to that rule if a consumer makes an inquiry on that call. So if a consumer inquires about the goods or services being offered. Now, if that's the case, if a consumer makes an inquiry, then a caller can call back that consumer within 90 days without violating the TCPA's D&C provisions, even if no purchase is made. So we see this in cases where, a call is made to a consumer, an initial call is made by a marketer, and that marketer doesn't disclose the identity of where they're from. And that's a big point because if they're not disclosing for their identity, the consumer supposedly fakes interest in the call to perhaps get the identity of that individual or company, and that call is then transferred to the lead buyer, who then does disclose the name of their entity. So what ends up happening is that the plaintiff sues the lead buyer who received the call transfer. And so that's what happened in the case Clemens versus Consumer Business Solutions. The plaintiff received a call and faked interest on that call. Then, because he faked interest, the marketer transferred that call to the defendant, and then the defendant talked about his goods or services. The plaintiff continued to express interest in those services, and the court ultimately found that the consumer made an inquiry on that call, and therefore the plaintiff and the defendant entered an established business relationship, and so any calls made after that call were not telephone solicitations because they were made pursuant to an inquiry. Important, though, is that the initial call, the plaintiff can still sue for the initial call, right? And so he couldn't sue for the calls made after the inquiry, but it's still important to note that if there's no consent on that initial call could still be illegal.
That was a fantastic breakdown, Baroness. I gotta tell you, that was great. Because usually I come in and like have some over-the-top kind of like takes. You kind of nailed it all, right? I mean, the takeaway there is the good news, right? You can't make up your own TCPA lawsuit, trolls, right? You can't get on the phone and be like, hey, call me back, he, and then sue. But you're right, because there's the other shoe there is, and just the scenario is always the same. Lead buyer is going to buy that lead, right? God knows how many times that lead seller made a call before they actually got the person on the line and made the transfer. Lead buyer doesn't have any visibility, right? They think, hey, first call, transfer, I'll take the call, why not? Person stays on the line, feigns interest, lead buyer feels like, good, this is a great lead. The guy stays on for 3 minutes, hits all the requirements to get paid on that lead. It's seemingly not a fraudulent lead, and then of course they ended up getting sued. But when that guy or gal, I guess, received all 1, 2, 10, 100 calls from the lead generator before the transfer took place, all of those are still actionable. And whether or not the lead buyer is going to be responsible for those calls is a vicarious liability issue, right? That's a different issue altogether. But what we do know, and it is helpful, is that once that consumer says, yeah, I'm interested, the lead buyer can feel safe calling, right? Because they're going to have that inquiry. So great job. You broke that down really well. I appreciate that. Dame, what do we got?
Well, mine's not particularly good news for the defense bar.
We'll skip you.
It's a big law loss. Massarello v. Power Home Remodeling. So far we've had the 7th, 9th, and 11th all essentially say the called party argument or the intended recipient argument isn't gonna work. It's whoever was called and paying for the subscription of the phone at the time, depending on what circuit you're in. But now we have another case, this Massarello case, out of the 6th Circuit, essentially affirming all those rulings and saying that the intended recipient argument is not going to work in their court either.
That's it?
That's what I have.
That's the whole thing? So look, you can't say big loss without big law. It's just right there. But I'm going to be honest, that particular ruling, I'm not going to beat up on big law too much because that's a tough road to hoe, right? A lot of the cases, as you've pointed out, a lot of the cases have, in my opinion, improperly rejected the intended recipient definition. And since we're talking, we might as well explain to the good viewers what that means, right? In order to have a TCPA defense, right, you have to demonstrate that you had the express consent of the called party. But who's the called party, right? If I, Eric Troutman, am using a phone that belongs to Pooja, but Pooja doesn't pay for her phone because Troutman Amin pays for the phone, and then I put the phone down and then Brittany answers the phone. If you are calling for Pooja, but Brittany answers the phone that I'm using, that she usually uses, that is paid for by Troutman Amin, who did you call, right? Now, because the defense looks at the caller's state of mind, to me, and since liability attaches at the time of the call, the called party is the person that the caller intended to call, right? I intended to call Pooja. Why does that matter? Well, because if Pooja filled out the form and gave you express consent, then you can rely on Pooja's consent if Pooja is the called party. But if the person who pays for the phone is the called party, well, now you have to have Troutman and Means consent. And maybe Pooja, in this case, Pooja probably is authorized to provide that consent. But in many instances, right, where you've got a kid using the father's phone or husband and wife situation, one might be paying for it, it's not always going to be a pass-through that just because somebody's paying for it and somebody's using the phone, that consent is going to go one to the other. And that's especially true when somebody else is picking up the line, right? So if Brittany sues the caller, she's obviously not the called party, right? Well, depending on how you define the called party. That's the whole issue, right? Who is the called party? And so in this case, the court held that it was a subscriber of the line. So you have to have, in the scenario I gave you, Troutman and Means consent. In the other scenario, when you're trying to call the wife, you have to have the husband's consent, or if you call the husband, you have to have the wife's consent, whoever the subscriber to the line is. And of course, that's a problem because you as a caller, you don't know that. You just know your customer that you're trying to contact. You don't know who pays for that phone and who doesn't. Now you can do things like have disclosures where they're promising that it's their phone, nobody else is paying for it, et cetera, et cetera, et cetera. But at the end of the day, this is a problem. It's just a flat problem. And the courts have gotten it wrong from the start. The FCC gave a glimmer of light with their 2015 omnibus where they said the called party could be either the subscriber or the regular user. So they had this weird binary definition, which was actually good for the defense because now you had at least two people, not just one, that could provide consent. But ultimately, unless you have the intended recipient as the definition, you're always going to have this risk of calls going to the wrong number, or not the wrong number, going to the correct number that you're trying to dial, but that are being picked up by somebody other than the person that you're intending to reach, or that are being paid for by somebody other than the person that you're intending to reach. And in either of those scenarios, you're strictly liable. You're on the hook. Period. Even though you did nothing wrong. Your crime was calling your customer, and your customer let somebody else use their phone. Or maybe they got rid of the phone and somebody else is now using that phone. You dialed the wrong number as a result of a reassigned number. But anyway, that went a little long, but I had to unpackage story because you went 30 seconds. But that's okay. Queenie, what do you got?
So before I get to the case I want to talk about, I do want to, just give an overview of DNC ATDS claims, because I feel like a lot of folks, especially when newer folks in the TCPA world coming to me for compliance, and this goes to advice for the case Brittany broke down as well, right? Understand that when you're calling back based off that inquiry that Brittany was talking about, you're only calling back manually, right? It was the case she broke down was only the TCPA's DNC rules. Mm-hmm. Likewise, with the case that I'm about to break down, understand this is under the DNC rules, right? Not under the ATDS or the regulated technology rules under the TCPA. So you want to be very careful when you're taking our advice or listening to our podcast. So there was another TCPA DNC case, Davis versus CVS, another retailer, text message case where, for those folks who watched last week's episode, know that we've had one favorable ruling after McKesson and one unfavorable ruling after McKesson regarding whether text messages are calls under the TCPA's DNC provisions. And so now we got a second favorable ruling out of Florida, Tallahassee, where the court found that text messages are not calls for purposes of the TCPA DNC rules. And interesting, the court, just flat out said no ordinary person is going to consider text messages to be calls. And so there you go, right? So now we have a favorable ruling that's on appeal actually in Illinois, but then now we also have this Florida case that states that text messages aren't calls. So pretty good news on the defense side. Obviously, we know that, or we expect that these cases are going to, different cases are going to come out, different decisions are going to come out across the country. But, a good data point, but understand this is not an ATDS claim. This is a DNC case. Yeah,
well, so that's the Davis versus CVS case. Now, it's big, though, on a couple of levels, because this was the chief judge in the Northern District of Florida. Yep. That's a big deal when the chief judge comes out. And you're right, the analysis was a little pithy. It was basically just like, look, the statute says thou shalt not make telephone calls, right, under certain circumstances, and no ordinary person is going to consider a text message to be a telephone call. And that's a good point. Mm-hmm. But that was also just the end of the analysis. And I got to tell you, the 11th Circuit Court of Appeal has some pretty good cases suggesting very strongly, if not outright holding, that text messages are subject to the TCPA. And this court was having none of it.
Yeah, those are all following, obviously, the FCC's guidance, right, pre-McKesson. But, you know, I did think about that. I was like, maybe this judge was just trying to shut down any type of arguments. It's in the 11th Circuit, right? He made his ruling, and that's all he wanted to have with it. So I suspect he's following McKesson, the rulings coming out. So I think he just wanted his word out and wanted his ruling out because it was out of Florida, really. So.
It will be fascinating to see if they appeal, because the 11th Circuit has been no friend of the TCPA recently. Correct. So it'll be interesting. Anything else?
Yeah, and then I just wanted to throw out another quick reminder. It's September 2nd today. By the time you guys are seeing this, it will be into the second week of September likely. Texas registration. The new Texas laws came out. We've broken it down. We have a compliance guide out there. It's on TCPAWorld. But my goodness, there's so much misinformation out there, folks. So I want you, the folks that are thinking about getting registered, whether they should or they shouldn't, use good counsel who really understands how to read the damn statute, right? Understand that you have Section 302 versus 305. 305 is going to regulate certain type of telephone solicitation calls. The 302 section is going to regulate the registration portion. There's different definitions in both parts of the statutes. So be very careful when you're trying to confirm whether you should or shouldn't get registered, whether your agent should get registered, right? Don't confuse the two statutes and trying to, make your own assumption on whether you should get registered. Really, talk to good counsel who's understanding what the requirements are. Wait,
did another law firm get the Texas registration rules wrong?
I've seen a few, on LinkedIn. There's no case law, so we'll see how.
But what are they saying? Like, what's the issue?
So
what are they saying that's wrong?
So what they're saying is that if you have prior express consent, you don't need to get registered.
Why is that wrong?
Why is that wrong? Because under the registration requirements, anyone who has who's doing telemarketing, and telemarketing is defined as whether you have consent or not, has to get registered.
So these people are just wrong. They're just out there giving quasi-fake legal advice, pretending that they know what the hell they're talking about.
They're looking at a different portion of the statute.
And they don't even read a statute? That's insanity. That's insanity. Who are you people? Stay out of the TCPA world. Go do something else.
And it's very unfortunate because a lot of clients are following, or they've already followed that advice from different attorneys.
I hope they get sued.
At the umpteenth hour, they're scrambling around trying to get registered.
This is like the 5th time we've seen this in TCPA world recently, where a new development breaks and other law firms try to weigh in. We just don't. We got it. We'll handle it. Just, read our stuff and tell the clients what we say.
And to be fair, no one was even talking about this until we blogged it.
Of course, nobody even noticed it until we.
The registration requirements were always there, folks. It's just there's additional penalties now, right? So all of a sudden, other law firms are talking about it when we've been preaching registration since we opened the firm.
Well, this was great. I love this, especially when we get to, talk about how other lawyers get it wrong. But let's talk to a lawyer who's going to get it right. And now, through the power of the Troutman Amin LLP law firm, I am so excited to bring you an interview with Jacob Ginsburg. And now, through the power of the Troutman Amin LLP law firm, I am so excited to bring you an exclusive interview with Jacob Ginsburg. Hey, Jake, welcome to the show, man. Long time no chat.
Oh, thanks so much for having me, guys. Really an honor.
Well, so you've been around for a little while now. Why don't you go ahead and orient the audience? Like, what's your practice looking like right now? Like, what are you focused on?
Yeah, so most of my time these days is spent on TCPA class action work. I started out doing a lot more individual TCPA cases, and I still do some individual cases, but most are litigated on a class basis. In addition to TCPA work, I'm getting into data breach and data privacy cases. And I also do Fair Credit Reporting Act, Fair Debt Collection Practices Act, and other general unfair trade practices. So the entirety of my practice is dedicated to plaintiff side consumer litigation.
So Jake, are you under your own firm now? Are you with Kimmel? Like what's your setup?
Yeah, so I work for Kimmel and Silverman, and been there for about 6 or 7 years now. And within that firm, I have cases that are really just more of my own cases, and still have the backing and the support of the firm, which is great.
Fantastic. So I know you're primarily doing TCPA class actions, which is obviously why you're here. Is there like a specific focus, flavor of TCPA class action, vertical that you focus on? What's kind of your focus? What have you been up to the last couple of years?
So I've, the cases, it really depends who comes to me, which clients come to me and say they have a case, or think they have a case. And it's mostly, telemarketing. I'd say mostly voice calls, although we still get some text message cases. We've had a lot. I've done a lot of cases recently against folks in the energy and utility sector. Also done a number of, done some, always have some cases against the home warranty companies. The car warranty companies have seemed to, a lot of them have gone under, but we still have some cases against them. And I find that we often end up in dealing with companies that are based in Pakistan, which is weird, but there seems to be a lot of telemarketing activity there. And a lot of cases seem to end there. There's also obviously a lot of American call centers, Filipino call centers, but obviously we can't sue those folks that are international with some exceptions. So and we do them all over the country. I am based in the Philadelphia suburbs. So if there would be a jurisdiction where I have the most cases, it would be the Eastern District of Pennsylvania, but do a lot in Jersey and throughout the country.
So what's your intake process like? I mean, does Kimmel just, Craig just throw you a case and say, handle this? Or do you have a lot of, you're vetting the people? I always am interested. Obviously, we're on the defense side. It's different. On the plaintiff side, kind of what your process looks like. How do you make sure they have a real case? How do you make sure they're not a scumbag before you file the lawsuit?
Yeah, so it used to be that I didn't have much interaction until a case was ready to be filed. I would then talk to the client. These days, a lot of it is referral based. I'll represent someone in a case and they'll say, hey, my cousin, my friend, etc. So it is a lot of referral cases, and then a decent amount of other plaintiff lawyers will reach out to me if they know where I'm barred, they know where I have cases, and I'll do the same with them. I co-counsel a lot with Chris Roberts, who you guys know, a couple cases with Max Morgan, Alex Kruzik, Ethan Preston. And, if I have a case that's in one of their jurisdictions, I'll reach out to them and they'll do the same for me. So there's a lot of that. And people get unwanted telemarketing calls all over the country. So when people know that I do that, they'll reach out to me and I'll see if I can help them out. It is very important to make sure that your client is telling you the truth. And that's the most important part of the process in intake. Another thing that's very important is making sure that there is correct identification. As you may know, a lot of telemarketers do not disclose the name of the company and who they are and who they're working for. So a lot of times people think that they're getting calls from a specific company, and then you do some vetting and you realize that they're not lying. They just misunderstand what's going on. So it's important to have that experience to figure out what's actually happening to the best that can be gleaned pre-suit.
Interesting. So, I mean, is there any case that you're really looking for? Like Jake Ginsburg just really likes it when he sees X sort of case? Or is it really just like, hey, whatever comes in the door, you're going to work it and do a good job for your client?
So I have to say that it's very hard to tell which cases are going to turn out to be the big ones. The cases where it has been the best result for a class with the most people and the biggest recoveries, those are companies that I hadn't heard of before the client came to me with a potential case. So you don't want to make rules about which case would be the biggest. I mean, there's a lot of times there's insurance at issue. There also might be a holding company or a parent company, and companies that seem very small sometimes will have the ability to pay, and then vice versa. Sometimes the opposite can happen. And a lot of times clients will come to me and they'll think that having the most calls makes the case the strongest, where you have to make sure that the calls are coming from the right source, and you have who they think the calls are coming from, and you have to make sure that they're actionable. It may be a case where there are 30 phone calls, but maybe the defense might argue that there was an established business relationship created in the seventh call. So still there are 6 calls, there are 7 calls that are actionable. So you just have to kind of reshift the focus and then explain. And of course, there are no guarantees. There are cases that 5-6 years ago I would have said that's a slam dunk, we can't lose. And you guys know how it goes. And some cases that seem very challenging that ended up going our way. So you don't want to make absolute rules about what the kind of case that you're looking for. You don't want to write anything off, and you certainly don't want to speak in absolutes. The most important thing that I really try to instill in my clients is that litigation is probabilities. There's a good chance at winning this. We have a tough argument with this. We may win, but we may not get treble damages. Maybe a class will be certified, but it would be there's all kinds of contingencies that you need to talk over. And the thing I really try to steer clients away from is the idea that a case is worth something. There's some kind of innate value to their case. My case is worth $100,000. And I say, no, your case is it could be worth $200,000. It could be worth 0. But it is worth whatever a judge or jury decides, or what the parties can settle for. So that's the pre-litigation conversation that I think is very important to have.
Interesting. Man, there's a lot there to unpack, but I'm just so curious about, how do you make sure that your plaintiff's not lying to you? Because you're going to go into court and you're going to face an Eric Troutman or whoever, right? And if your guy is not telling the truth, we're going to go out for blood, right? So you've got to make real sure before you show up in court. So I'm just curious, what's that like? How long do you spend talking to people? And does it matter if they filed a lot of cases before? Are you interested in those repeat litigators? Do you try to stay away from those guys? I'm just interested in what your mindset is.
Yeah, so that's a great question. I can, again, I don't certain things I obviously the attorney, all the attorney-client interactions don't want to necessarily get too granular, but people, before any plaintiff lawyer puts a case into suit for a client, that client needs to know that what they say will be challenged and will be subject to scrutiny. And if they welcome that, then it's a good feeling. If they don't, then that's when you know to stay away. And there are certain things that you can tell, and you can look at the patterns and what we see, and it's usually you get a good sense of whether if someone is willing to put all of that out there, then it seems like they're not going to do that if they are lying. And obviously, lawyers who take cases on a contingency are not going to want to do that and to do all that work just to find out that what they heard pre-suit was not true. So it's a very important conversation to have, and it's not something that you can skip. So it's important. Now, in terms of repeat litigators or whether someone has filed suit before, I actually had a case that in the Northern District of Texas, it was an individual case where my client was a newscaster and he did consumer news for a Dallas Fox affiliate, and he had a segment on the TCPA where he had a stack of money and he talked about all the calls he got. And we got that excluded from the jury. The jury can't see it because it could poison them. But in that, we argued that a bipartisan Congress and President George H.W. Bush decided that the way to stop unwanted robocalls is for private citizens to serve as private attorneys general and to file suit. They may be motivated by money, but as long as they're telling the truth and everything is brought in good faith, there's nothing wrong with the fact that that would motivate them. It is anyone who's willing to go through all that litigation entails understands that it's about a greater principle too, because what can be recovered in a typical TCPA case is generally not worth all that you have to go through going through litigation. So most of our clients understand that. If someone is a repeat litigator, there is always an issue of degree. There's a difference between filing 3 cases and filing 100 and 200. But if someone has, and I've had to explain to judges before, because I have clients, I had a client who filed maybe 2 or 3 cases, and the judge said, well, isn't this a serial plaintiff? And I said, yes, like all Americans or most Americans, he gets robocalls, he gets unwanted telemarketing calls, and unlike most people, he knows a lawyer who does TCPA work, so he's filed a few cases. That doesn't make his cases devoid of merit. So I don't shy away from people who have filed multiple cases. You do need to put yourself in the shoes of a judge or jury. If someone has filed a ton of cases, that can be okay, but you need to think about how that's going to come off and if it's worth doing. But if someone has filed a few cases before, that's not a bad thing. It means they know a little bit about the TCPA. They know what discovery means. They know how to document calls, how to keep records, and they understand, that they understand what the litigation entails. So it's certainly not something that I would say is a strike against someone if they filed a few cases. That wouldn't bother me.
Okay, interesting. The concern is always that they file these cases that maybe they're setting up the lawsuits. But you're right, people do receive calls from different people over time, and I guess that makes some sense. Let's talk about some of the recent developments. We were talking earlier in the podcast about a case called Davis versus CVS. And this is the second court in the country. You're already nodding. You know exactly what happened. That held that an SMS message is not a call for purposes of the TCPA's D&C requirements. What do you think, man? This new wave of cases, not a wave, it's just 2, but the idea that case law is shifting away from treating SMS messages as subject to D&C protections and other potential case law developments following McKesson. How is that impacting your practice? Like, how are you pivoting, if at all? Are you just going to keep steamrolling straight ahead? Like, what are your thoughts?
Well, it's one more thing to fight about, and that's nothing new. As you guys know better than anyone, it's the landscape of the TCPA is always changing. Just like to the going the other direction, it looks like ATDS maybe slightly resurrected from the dead, but
Might be.
So the law is always changing for better and for worse. Obviously the Supreme Court decisions over the last year and a half have created more challenges, because what was settled law with FCC rulings are now being challenged all the time. What I would say about the SMS messages, there's the statutory part about what's a solicitation. And then there's also something that's important, is that Congress has amended the TCPA 3 or 4 times since the FCC said that a text message is a call. So if Congress amends a statute where the statute says that an agency can make rules, there's Supreme Court precedent, which has been followed by circuit courts around the country, that says that Congress therefore adopts the agency interpretation if it leaves that portion untouched. So Congress amended the TCPA a number of times and never did anything to disrupt the fact that a text message is considered a call. So that, I think, is a very important argument for plaintiff lawyers to make. And in terms of that decision from the Northern District of Florida, and there was another one, I believe, from the Northern District of Illinois, which is being appealed. So the case law will vary. You're going to have district courts that go, in our view, the wrong way, for your view, the right way, and we'll keep fighting about it. But it certainly creates a new challenge, and it's just another hurdle that we have to clear.
It is fascinating, because literally right before these cases started coming out, I think you said Northern District, I think it was the Central District of Illinois was the Jones case. Yeah. Literally right as the big wave of TCPA, DNC, SMS cases was coming out, right? I was like writing about this. It's like the biggest wave, right? Particularly around revocation, but just like the SMS focus on DNC. Now the argument that like neuters it feels like the ATDS stuff all over again, right? It's like, this is the big wave, and there's gonna be cases going everywhere, and yeah, you're gonna have something of a crapshoot, because maybe, I think the majority rule is still gonna be that SMS are subject to the DNC rules, right? But you're gonna get like maybe 1 in 6, 1 in 7 are gonna get picked off, right? So now you're gonna lose 16 to 17% of, what is 1/7? 14.2857% of your cases you're going to lose because of this unexpected reduction, because of this, new rulings that the SCOTUS has opened up. I think that's fascinating. I mean, it's fascinating for us too, of course, because we're like looking around at each other like, let's get some motions for, judgment on the pleadings out there, because it's the same calculus. Like, yeah, thanks to Big Law screwing this up early on, we're going to lose, more than we should on this argument, because, you made an argument. I'm not going to waste everyone's time kind of making the counter argument, but there is really good reason to think that Congress did not intend to cover SMS messages, mostly because, they didn't say that, and they have amended the statute, and they put it into different places, but in these places. But leave all that alone. At the end of the day, we know that we're not going to win all of these, but the defendants are incentivized at this point to take your shot, right? And you have to be smart. You have to think about pre-certification, post-certification, making common issues, do it at the pleading stage, do it at MSJ. Like, you have to be strategic and not just like throw it against the wall. But it is an opportunity that's now open in pretty much every TCPA SMS case, and that's got to feel good. It feels good for us as the defense side. That cannot feel good on the plaintiff side. Peronic always talks about the value of his asset. And I know you said there's no determined value. It's like, quantum physics for you and Schrodinger's cat. And maybe you're right. But, I always laugh at Peronic, because it's just like, my asset is worth X, and, you're either going to pay me that or I'm going to fight. And as I fight, my asset's going to appreciate, right? But, you take a hit like Davis coming out, that's the chief judge in Northern District of Florida. I mean, that has got to hurt. It just has to hurt, Obviously, it's not an appellate court decision. Who knows? Maybe the 11th Circuit goes the other way. I mean, you don't know. I think you get a better chance in, Seventh Circuit than you do in the 11th.
Yeah.
Go ahead.
I have no direct dog in that fight, but the 11th Circuit's tough. The Fifth Circuit's tough for our side. We'll see what they do. I mean, the 11th Circuit reversed the Salcedo decision with Drazen for standing. So maybe the 11th Circuit would make a good ruling for our side, but it's going to happen. There are going to be more judges who follow that. And on the plaintiff side, you have to think about judicial assignments as well, and which fights are worth fighting and which aren't. And I just, and that's obviously true on both sides of the bar as well. With certain judges, it's not smart to fight that fight. So, but yeah, there are going to be more rulings like this, and yeah, was happy to see that the Kazaruni folks, who I have a couple cases with them as well, but I saw that they appealed the Central District of Illinois case to the Seventh Circuit, and yeah, excited to see how that one goes.
It's interesting. So when you are evaluating, and we talked at Veronica about this at some length, right? You plaintiffs' lawyers, you're way more strategic, and really you've got more opportunity to be strategic than most of the defense attorneys, because when we get a case in, we're kind of stuck with it, right? I mean, unless we write you a big check, it's not like we can just dismiss the case. Like you're driving the ship, not our client. So if you've got a bad case in a bad jurisdiction, or against opposing counsel that you don't want to deal with, you can just get rid of the case, right? The defendants can't do that. Like we are pretty much trapped. So that's a good opportunity or a good advantage that the plaintiff's bar has, and you guys use it to very good effect. I was telling Peronic, our firm is basically benched on all these issues, right? None of these are our cases because you guys don't litigate them against us, right? You litigate them against, other, maybe lesser, I don't know, attorneys. Wow, what a surprise, you end up winning, right? And it's very frustrating because I have to sit here and watch all this bad case law. And of course, I read every case, and I blog about it. I get so frustrated because it's like, man, let me in there. Put me in, coach. Like, let me go handle this. But you guys are very smart. You keep us on the bench. You don't litigate the stuff against us. I asked Veronica to ask you, when you're evaluating a case and you're trying to decide, is this one you're going to push or not, what's more important? Are you looking more at the judge, or are you looking more at opposing counsel when you're thinking about, or is it facts, or is it something else? When you're thinking about which case you really want to push and which case you're thinking about resolving?
So the jurisdiction and the judge are very important, as is the facts. The specific facts of the case are what I find to be the biggest driver in terms of whether we pursue the case as a class and seek certification, or if we settle individually. If there are some cases that are very compelling facts for the individual, but you learn that it's unique, or there's some kind of problem that would make class certification very challenging, the solvency of the defendant is a really big issue that we deal with a lot. I've had a number of defendants file for bankruptcy, or just stop paying their lawyer halfway through litigation. It happens a lot. So those are all factors that we think about, as well as, who is the defense lawyer is certainly something that we think about. I don't want to say something I regret, but I like when the defense lawyers fight that may be, not always the best financially, but it's fun. People go into litigation because they like the fight. So it makes it more interesting when we get pushback. Obviously, you get a really aggressive defense lawyer and a judge that is relatively pro-business, that's kind of like, all right, this is shaping up to be an outcome that I don't want. So that those are all things that you think about. The client as well. Obviously, clients sometimes at the outset, they're all about the class and making the business change, and they're competitive too. They're all in, but then, something happens, they get sick of it. Why is this still going on? Why do I have to respond to discovery? What, the clients obviously, so there's a lot that go into the decision in terms of how a case is treated, and you deal with it as it arises. You don't want to have a predetermination of where a case is going to go at the outset, because it never ends up that way.
Well, let's talk. Speaking of cases, you had no idea how they were going to end up. You've got a case against Charter, and I blogged about this today, and this is actually what made me reach out to you to put you on the podcast. I just think this is just such an amazing story. You've got an individual suit against Charter. It's like there's like 30 calls at issue, and you filed this thing back in 2020. This is like 5 years ago, and you are still litigating the case to this day. Over 30 phone calls. The case is worth like $45,000, like dripping wet. It came to my attention because just today the court entered, or I guess it was like Friday, the court entered a default against one of the co-defendants. It wasn't, so Charter allegedly had some Pakistani call center called Tranche, I guess, was allegedly making the calls on its behalf. And after Tranche originally got defaulted, then they hired a lawyer apparently, made an appearance, and then promptly fired the lawyer and didn't respond to discovery. And so they ended up with default entered like 5 years later, which is crazy. And then also crazy is you guys just argued a summary judgment motion that apparently you filed back in 2023. Anyway, give me, I know that it's an ongoing litigation. You can't tell me too much about it, but give me what the hell is going on in Alabama, Jake? This is crazy.
Yeah, so this is probably the best example of a case where you just have no idea what you're going to spend your time on and how it's going to go. I've had, cases that we've settled, 7-figure sums, class actions, and I definitely spent way more time on this individual case in Alabama with 30 phone calls. I did, and it's not close. There was, again, I don't want to talk too much about ongoing litigation. Just in terms of what's on the public docket, we did, the early part of litigation was focused on a falsified recording from Charter's vendor, and Charter's vendor acknowledged the falsification. After they hired counsel, filed an answer, and said, yeah, we falsified the recording in Pakistan. Then they stopped paying their counsel, and now we've defaulted them. And litigation with Charter is ongoing. And yeah, the case will celebrate its, I guess it's fifth or sixth. Yeah, it's fifth. Yeah, it's fifth birthday in a few months. And
it's going to be half a decade old. Congratulations. But no, tell me about this. So Charter hires, was it a direct hire? Was there intervening calls, like a lead generator in between Charter and the call center in Pakistan? Because I mean, the fact that a Pakistani call center causes trouble, not a surprise to any of us. Those guys, we tell our clients, don't work with these guys, right? Because I mean, I'm sure there's a couple good ones. I assume. I don't know. I've never met one. But the fact that the Pakistani call center just came out and was like, yeah, we just made up a recording. I mean, that's crazy. But is Charter really responsible for that? I mean, I'm sure if Charter was here, they'd be like, dude, we had no idea that these idiots were making up recordings in Pakistan. Of course, the counter is, well, what do you think they're doing in Pakistan? Help me to unpackage that. How is this going to fall on Charter? Why the hell did they admit that they made a fake recording? It's just so weird to me.
So the fake recording, I mean, again, this is all on the public docket. There's a protective order in the case. I certainly wouldn't do anything to interfere with that. The recording was clearly falsified because we got AT&T phone records, which showed that it was an incoming call that my client received. So that pretty much spoke for itself, and we got some stuff in discovery. So yeah, we would certainly argue that a defendant would be vicariously liable. There's the three theories of vicarious liability. Charter would, of course, argue that it's not, and we'll see what the court says. Got very, very good defense lawyers on the other side, and yeah, we'll see where it goes, and hopefully, I never have another case with 30 phone calls that gets to docket entry 200.
Yeah, well, it's funny because we tell people all the time, and you're not going to like this, but I got to be honest with you. Like, if you're a defendant and you're getting pushed to the Berber, like, you know, you're a mark. Like, the plaintiff's lawyer has decided that you, as a TCPA defendant, that you are not strong enough that to be taken seriously on an issue where they want to create law on you. When I look at what Charter's up to, Jake, I mean, I think they're trying to make law on you, man. I think they see you and they're like, you know what? We're in Alabama. I don't know who the judge is, right? But I mean, I'm imagining Charter's done its homework. They do have the Watstein firm. They're very good. I agree. I actually like those guys. They're in my top 10. So I don't just like the defense lawyers. Many times the defense lawyers are morons. They are not morons. These are good attorneys. But they're spending, I'm going to guess, they're spending a high multiple of what they could have settled the case for, right? And look, I've got clients that will do that, but usually it's because they're being strategic. It's because they think they've got a play, an angle. Do you think, and does it matter, I guess it doesn't matter either way, but do you think that Charter is like, hey, look, we've got a chance, for instance, to prove that we're not vicariously liable for what our knuckleheads in Pakistan do, in this case in Alabama, so we want to take this shot, and that's what this is all about? Or do you think it's just like, hey, look, they just fight everything because that's their philosophy?
Well, we went to mediation with them. The case is a matter of public record, but yeah, we pushed hard for the first couple of years that this case was in suit, and we felt strongly about it, and we got a lot of things in discovery that I mean, it's, you know, I don't want to speak too much about it, but we feel, and we've gotten some good rulings in the case so far, so we're not concerned about what Charter might do or argue. Charter fights everything very hard, and I respect them. I've had a lot of cases against them over the years, and it's we're however the case ends up, we fought the good fight, and we feel pretty good about it.
Well, if you do win it, I mean, you're going to be spiking that ball in the end zone because, I mean, that's going to open up Charter, I would think, to a whole bunch of vicarious liability issues, not just in this case, but in others, maybe on a class-wide basis. So, I mean, I don't know. To me, if you're Charter and you're seeing through a 30-call individual suit to a summary judgment motion on vicarious liability, like, you've got to be smart enough, and I'm sure that they are smart enough. I mean, you've got to be smart enough to realize that if you lose this, I mean, all this happened to Allstate. Allstate did the same damn thing up in Illinois. Individual suit. They lost. They got summary judgment entered against them on the finding that they are responsible for what the agent did. That crushed them in other ongoing class litigation. All of a sudden, like a string of settlements comes rolling out, right? It cost them millions of dollars to do that gamble. I am sure that Charter is smart enough to know that if they lose this, you just went to the mat on a 30-call case that you could have settled. Look, I wasn't at mediation. I don't know anything. Don't tell me anything because I don't want to know. It's confidential. But I'm going to guess that it could have gotten done for under $40K. You can tell me I'm wrong, but I'm going to guess it could have gotten done for under $40K. And I guarantee you they've spent more than 10 times that in this case, looking at the docket. So to me, this is a strategic decision, and it's going to work out or it's not going to work out. And I am really interested to see how it goes. If it works out, good for them. It was a ballsy move and it pays off. If it doesn't work out, it's like you're going for, you're at your own 45-yard line late in the game, and you're down 1 touchdown with 2 minutes to go, and you go for it. And it's like, well, wait a second, you got 3 timeouts. Like, why didn't you just punt the ball and try to get it back, right? It's like, you're gambling, and if it pays off, you're a genius, and if it doesn't, you're a moron, right? And that's where they're at. So anyway, I don't need you to respond to any of that. I don't want to get you in trouble, Jake. Those are my thoughts. But go ahead.
Yeah, so I've had a number of cases against Charter, and most of them have settled. This one, it's just really been litigated to a hilt. But I can tell you, the company SunPath. I don't know if they're still in business. They're a car warranty company. So I had a couple cases against SunPath, and they moved for summary judgment and won in the Middle District of Tennessee. And then we overcame their summary judgment in the Southern District of Texas. So it was the exact same contract, the exact same analysis, but courts came down different ways. We had that also with Dish Network. We had a case, we had 2 summary judgments with that Dish Network filed. This was probably 5 years ago. And in the Eastern District of Pennsylvania, we overcame their summary judgment. In the Western District of Texas, they got a summary judgment their way. So vicarious liability is something where judges come down very different ways on the same issues.
Maybe. I don't know. When I win something, I win it forever. I've never won something and then lost it later. Like, that's just never happened in my career. But maybe other people, this happens to them. I don't know. Sorry to cut you off, but anyway. So I appreciate you coming on, Jake. You've been out here for a while. You're an interesting guy because the course of your trajectory in TCPA world, you did bring a lot of individual suits. We saw you commonly in individual suits. Several of our individual suits that we were litigating, I thought in the back of my head, like, what the hell are we doing here? Like, this case is worth 10K, man. And we're fighting you, but we're not going to fight you for 5 years over 10K because, at some point, that's just unethical, unless you've got a real strategic plan. So I'm glad you came on, man. I really wanted to have people kind of get to know you a little bit. You're not as known as the Peronics or the Kazarunians or the Greenwalds of the world, but you're definitely a player in TCPA world, so I wanted folks to get a chance to kind of meet you. So look, we end every interview with the same question. Actually, before I do that, Pooja, do you want to ask any questions, ladies? You got any questions for Jake?
No, since you traditionally were focused on individual suits, what makes a good case, in your opinion, for a class suit? Like, what kinds of factors are you taking into account?
So for class cases, you often don't, it's very hard to know before you get to discovery, but you want to have something, and this likely goes without saying, but to avoid a bunch of individualized inquiries. So for instance, we had the Burnett call court case in the Southern District of Texas we settled. Every one of the people in the class, their data came through the same website. So either that's a valid website for getting consent or it's not. It's the same inquiry for everyone. It can be the same call center that made calls for one of the sellers. If they have the same call center or telemarketing vendor that made all the calls, then it's the same vicarious liability analysis for all of them. So it's the kind of thing that's very hard to know before you put the case in suit, but you learn in the course of discovery. Obviously, the defendant's solvency is important and something that you have to think about from the outset. And then you have your client. A lot of times clients will be gung-ho at the outset, but then they get sick of it. You never know what's going to happen. So those are all things that you think about, but you don't want to define a class in a way that is overly broad, because pigs get fed, hogs get slaughtered. So
Yes,
that's certainly, yeah. So you just want to be smart. Don't get too greedy, and you want to be able to say, okay, it's the same inquiry for all of these people. So it's foolish, in my view, to have, I mean, obviously you put a class definition in your complaint, but as the case goes forward, it likely will be narrowed, and you just want to think about what will overcome scrutiny of the court and overcome tough defenses about the individualized inquiries.
Hey, you mentioned solvency a bunch of times. Do you ever sue the officers or the CEOs personally?
Yeah, we have. We've had cases where we go after individuals. That requires, courts sometimes don't like that, so you need to have a good basis for it. But certainly if you learn something, that can be a good reason to do it. And it's been successful. It's been unsuccessful sometimes too, but it's a way to get around a company that may be cash poor. Also, parent companies can be a good way to do it.
Yeah, Peronic has been very clear. The Wolf has been very clear that, you know, someone cries poor to him from a business standpoint. He's like, all right, I'm going to sue the owners, right? And that's, you know, his mindset. I think that's terrible, obviously, but I was just curious if that was your mindset. Anyway, man, this has gone a little bit long. That's okay. It's great to have you. You've been a great guest. But we end every interview the same way, and we ask you, you know, in your mind, you can answer this however you want, for your clients, for industry, for society. You know, what can people do to deserve to win?
To deserve to win, if you're a plaintiff, you take good notes, document everything, and think about the big picture and, you know, why you want to get folks who skirted the law to change their ways.
All right. Well, good answer. Well, Jake, we appreciate you being on, man. Thanks so much.
Thanks so much for having me, guys.
Wow. Okay, so let me just start by saying I like Jake, but man, he talks way too slow. I mean, I was like trying to get information out of him, and I felt like I got the same amount of information I would get out of a normal guest, but it took twice as long to get it. And no disrespect, Jake, but just the cadence there. He was very cautious, I think. He was choosing each word very carefully.
I was going to say he's thoughtful. Like,
well, that's the other way of looking at it, right? I view this as cagey, because I'm a quick thinker, I'm a quick talker, right? And so if someone's quiet or they're a little slow, I'm like, what's this guy hiding, right? Whereas they look at me and they're like, this guy talks too fast, I can't trust him, right? You know what I'm saying? So it's just a matter, it's like extroverts always trust extroverts and introverts trust introverts, and they don't necessarily trust each other. I know I don't trust introverts at all. I mean, because Brady, you're a little introverted, and I'm like, hey, what are you thinking? Tell me everything on your mind right now. Speaking of which, hey, what are you thinking?
Hey, no, I thought it was great that you brought him on the podcast, because just as you mentioned, he's not one of the bigger players and names that we see in the TCPA world, like Pronic and the Green Worlds of the world. So it's nice for the TCPA world folks to hear from Jake and kind of hear his perspective on what he's looking for when he's intaking cases and individual versus class cases. And so, yeah, I thought that was interesting. But there was one thing that caught my attention, and he did mention, like, he looks at the solvency of the business. And he said that multiple times, so that's why it caught me. And so it's important for these folks and businesses to remember that there is personal liability under the TCPA. I know Pronic's way of thinking at it is, if you cry to him that you don't have any money, then he'll directly go after you personally. But it's nice to get other plaintiffs. It's nice to get other plaintiffs' counsel's take on whether they would sue, you know, a CEO personally. And so, yeah, I've dealt with Jake many times in cases, and so I agree with both of you. I think he is cautious, but he is also just thoughtful in his approach. So yeah, I enjoyed him.
Well, very good content today. Appreciate you, Baroness. Fantastic. Good to have you back, by the way. Dame, what are we thinking? My fiery red dame?
Well, you know, my ears perked up whenever he won a motion in limine to get the news reporter that he represented footage. The fact that they knew about the TCPA, they knew how to set these up, they were giving advice to the public on this, and got that excluded.
That got excluded.
Yeah,
That's pretty wild.
so I want to look into those motions just to see how the hell that happened. But I like Jacob a lot. I think he's a good attorney, and I'm happy that we had him on.
Okay, very good. I appreciate that. And also, fantastic job today, Dame. I always appreciate you. My dear Queenie, what are we thinking?
So, I mean, first, I just hope you folks watching this realize how incredible our podcast is, right? And the reason I say that is because look at the different folks we bring on, right? It is so important for you folks who are facing TCPA litigation or are trying to comply with the TCPA to really understand that Troutman Amin brings you this information so you can see who you're going up against, who you're dealing with, and unfortunately, right, Eric's had this long practice in the TCPA world where we have had the opportunity, I guess, to deal with different types of plaintiffs' attorneys, right? And that's going to also impact the assessment that we give you folks when we're handling your cases and evaluating who we're going up against. And that's what I thought was really neat. I agree with Tori that we were able to bring him on because sure, he's a slower talker. He's definitely not as fast as Eric, right? He's kind of like that Alabama football team that doesn't really know what they're saying, and they're just like going really slow. And it felt like you guys were talking about football for a really long time. And I know nothing about college football, but it sounded like that. But for him, what I liked about it was he was thoughtful, but his approach and his cadence of speaking also matched the thoughts that were coming out, right? Like if you think about when he was talking about the class, whether he brings class cases or not, he really focused on, well, I'm not going to bring sloppy cases that are, eventually going to be a waste of my time. I'm going to look at the class definition, I'm going to look at the background facts, I'm going to see if there was actually just one website or multiple websites involved, as opposed to dealing with that later on, right? So a lot of plaintiffs' attorneys they bring this like aggressive approach where they're just filing these cases and then hoping, it's an individual settlement and then they'll fight you on certification. But I liked how his approach to cases and the way he was speaking, they went hand in hand, right? And so I don't think he's a fool, right? Even though he's slower speaking, I think he's a well-meaning attorney and who brings very thoughtful cases for his clients.
We're gonna have to teach you about college football.
Yeah, okay. Whatever.
You keep threatening to learn about it, and
Go
with
Cal.
exactly, with our logo on the field. You're gonna have to learn.
Is Alabama a good team?
Alabama, traditionally, they're amongst the best teams that have existed, and they're pretty much known for speed. So to characterize them as slow would probably be the wrong team to have
Well, you're
picked.
comparing the Alabama case to football, so I don't know where you were going.
Well, I did have my analogy I think stands, which is just that Charter was taking a big gamble, and in football, there's like these different strategies and theories. And I'm one that always I'll trust my defense, right? I'm a defensive-minded person. I'm going to trust my defense. I'm going to punt that ball away. I'm going to trust my defense to give me that ball back with some more time on the clock, hopefully with better field position, right? That's the thinking. Whereas different people would, in that same scenario, go for it, but that's it. That's fourth down, right? If you don't convert, that game is over. Right? They have to take 3 knees and the game's done, or maybe they have to still, run a couple of plays. But to me, the analogy is when you're talking strategy. Right, where do you ultimately lie? And Charter has made a decision. It seems, I don't know. I'm on the outside looking in. Right. I'm just kind of trying to figure out what they're thinking. I mean, I guess it's possible they're just dumb and not thinking about it at all. But I don't think that's happening. I think they're thinking through. They're making a strategic decision, and they've decided, hey, we're gonna take this shot. And I disagree with Jake when he was suggesting that judges go different ways all the time. Baloney. Charter loses this. That's going to stick. They win this, it's going to stick. So I'm looking forward to seeing how that turns out. But yeah, look, I think Jacob he's a hardworking guy. I think most of the plaintiff's lawyers are in it for the glory. Not me. Just kidding. Look, I am. I love being good at what I do. I love making sure people know about it. Right? Jake is a guy, honestly, he's pretty good at what he does, but he sincerely doesn't care if people know or don't know. He does nothing to try to draw attention to himself. And I thought it was interesting to like get him on and, you know, hey man, talk. Like I want people to see you. And he just really was like the yeoman, like the hard-working guy that picks up his axe and goes and chops down a tree every day. Like that's who he is. He's a lunch pail kind of guy. It was worth seeing. So I hope that you all enjoyed that. And I know we enjoy chatting with you. So much going on. So excited. I know you guys are part of the Trump-Minamine rocket ship. We talked earlier about all the incredible stuff we have going on. We love having you guys be a part of it. I really hope you love the new website. Send us a comment. Send us a like. Let us know if you're liking the website. If you hate it, tell us that too. Tell us why so we can fix it. Because we really want this thing to be a shining beacon to the world. And I think that we accomplished that. But anyway you look at it, we loved having you here on this, our 36th edition of the Deserve to Win podcast. We'll see you next time. Bye, everyone.